And we're back with Talking Law TV. We're here with Doug Andrews answering viewer mail questions.
Let's do it.
Okay. First, Jim from Tybee via TalkingLawTV.com. I was on a jet ski doing nothing wrong, was flagged down by a DNR officer, that's Department of Natural Resources, who gave me a ticket for not having a driver's license on me, and he arrested me for boating under the influence. I had only had a couple of beers. Apparently, I hadn't had any. Can he do that?
Well, apparently he did. He can. You are legally, by statute, required to carry identification. So that first issue, yeah, he can write you a ticket if you don't have identification. Now, they usually ask for driver's license. Well, if you're 16, you may not have gotten your license yet. You're supposed to carry your student ID with you. I mean, nobody thinks about that. But DNR can stop you, as well as any other Marine law enforcement officer, Coast Guard, Marine Patrol. All of them may stop you with or without justification, just because they want to. It's not like an automobile that they have to have reasonable suspicion. On the water, they can stop you just because they want to check you out, making sure you've got a safety lanyard on a PWC, personal watercraft, making sure that you have adequate life preserver on, that sort of thing, and whether or not you've been drinking. Obviously, the whole scenario changes once the officer detects the odor of alcohol. Now, what does the officer do next is the issue. You know, you're not going to be walking on the water, and we killed the last guy that did that. So they sometimes will try to do horizontal gaze nystagmus on the water, but you have to keep your head still. So if you're going like that, that's also problematical. So if you're boating, don't drink till it's over, unless you just want to gamble your freedom and pursuit of happiness, because it's going to be taken away from you if you get stopped for any reason.
Now, I'm curious, you said it was required that you have your identification on you. Is that from motor craft, or it could be like a sunfish sailboat?
I think it's limited to boats. I don't think it's non-powered. I would have to double check that, though. I think it's
curious,
powered
how many
vessels.
people carry a wallet on the water?
Not many. So you have to put your stuff in a baggie or a Ziploc.
Okay. Our next is from Steve from Jacksonville via toll-free line. I pled guilty and was given probation. Now I found out I have to meet with my probation officer each month in person. I live in Jacksonville.
Oh, well, Steve, why don't you ask your lawyer? He probably didn't have one. And the sad truth is, they could make you report by mail report in person every month, no matter where you live, unless you get the judge to authorize a substitute form of reporting. Some places will let you phone in the probation officer every month. Others will require a written form to be filled out. I'm living here, working here, and so forth, not been in trouble since last report. And you mail that with your monthly supervision fee to the probation officer. So he can request of the probation officer, how do I go about getting mail-in reporting? And the probation officer may say, well, get a lawyer to ask the judge to sign an order authorizing that. Some probation officers are given permission by the court just of their own decision-making to allow that kind of reporting if that makes the probation officer happy, if the person's been compliant with everything and so forth.
I learned something from another caller that's sort of related to this. This person had called and told me about their probation fees, and I wasn't aware. He said he paid $260 a month in order for the privilege to be under probation.
Well, that's excessive. Most of the probation companies in this area charge $50 or less per month. For some reason, there is one town in Chatham County that is much higher than that. I don't know what authority, because I thought it was set by statute. I haven't looked at it, but that's way too much. Now, that amount might include his fine payment, because frequently, if you can't pay your fine in full, that's why some judges will put you on probation when they wouldn't otherwise, like the guy in Jacksonville. Unless it's DUI, then probation is required by law. But they will set you up an installment plan, and so then you pay the probation fee along with your monthly fine payment, and so that could make it $260. But other than that, I smell a rat.
Okay. Our next one's from Lindsay in Richmond Hill, who's been married for 3 months, but it's clear she made a serious mistake. It's not working. Can I get an annulment?
Annulments are a creature of statute, which means there are limited grounds for that. Usually, just speaking generally, you have to show some fraud or incapacity at the time you entered in the marriage. Let's say that he failed to tell you that he was a convicted child molester and you didn't know that. And that might be grounds for an annulment because you would not have contracted had you been fully informed and he deceived you into thinking he had no previous history. So there has to be some fraud involved in the marital relationship or an incapacity. For example, he's already married to somebody else, so it's technically bigamy. So you wouldn't get a divorce in that case, you would just get an annulment. But just because you made a stupid decision isn't legally grounds. However, sometimes a studious lawyer can come up with sufficient reason to fit it into the annulment arena if both parties agree that that's true facts.
Okay. Our last question is from Skip from Lansing, Michigan, who was vacationing in Savannah and was recently arrested for DUI. Does he have to appear in person in court?
Well, you know what we say, come here on vacation, leave on probation. It happens. In many courts, if you obtain a lawyer and get guidance of the lawyer what the type of offense is, it may require different things. But in most cases, a lawyer for you can enter a plea in absentia. That means in your absence. Basically, the form says, I understand my right to be present. I cannot attend because of hardship. I live a long distance away, or other reasons it would be a hardship. I waive my right to be present, waive my right to a jury trial, and therefore authorize a plea to be entered on the following basis, and it says what the charge would be he's pleading to and what the sentence might be that he consents to or understands would be given. And if all requirements are submitted at the time of the plea, for example, if he has to do community service or pay a fine, if all those things are furnished so it's a done deal, completed, most judges will accept it. Now, there is one judge in state court that absolutely doesn't like it. He'll make you fly back from California to enter a guilty plea to DUI if that's what you want. Other judges are a little more accommodating for that situation, but every judge is different.
So I'm guessing for not guilty, you need to be here.
Absolutely. Now, I've twice recently had the presence of the defendant waived just to do the motions hearing to try and knock out evidence, but at trial, and the judge granted that, at trial, you would absolutely have to be here for trial in front of a jury.
Okay, thank you, Doug. If you enjoyed this episode and have questions of your own you'd like Doug or one of the other attorneys to answer them, you can reach us through our toll-free number at 888-203-7LAW or through the website at TalkingLawTV.com. We'll see you again next week right here at Talking Law TV. Bye-bye.